The Illinois Supreme Court hearing cases this week, and yesterday they had 4 of them. Several were rather fascinating. One dealt with whether or not somebody who was found with cannabis when it was medicinally legal should have had that evidence thrown out. Another dealing with a bicyclist in Chicago that got hurt after hitting a pothole, and whether or not the city should be held liable for that. So we'll have to unpack that case here in the future. But another case that was heard yesterday talks about the intersection between the Freedom of Information Act and the firearm owner identification card, and whether somebody who is denied or had their FOID card revoked can get access to the internal state police documentation about the reason for that particular denial or revocation of a FOID card. So Freedom of Information, it's a law that allows for the public to get access to public information held by the government. The government works for you, the taxpayer, and therefore those are your documents. That's really the spirit behind the Freedom of Information Act. But what about those who get their FOID card revoked or suspended? What kinds of information do they have access to? That was the crux of the arguments brought in front of a Illinois Supreme Court hearing yesterday. And just go ahead and dive into this because there's a lot here. Here is the Illinois State Police Attorney laying out really the background of the case and their arguments as to why they should deny this particular case for the plaintiffs seeking their information through FOIA.
May it please the court, I am Valerie Quinn here on behalf of the Illinois State Police. The language in Section 7.5b is plain. It unambiguously prohibits the disclosure of people's FOID card information without exception. And it is clear that the General Assembly did not intend to include an exception of any kind in that prohibition because not only in the same provision, but in the very same sentence, the General Assembly explicitly allowed for an exception for information of applicants for a concealed carry license. Under the basic principles of statutory construction, that omission has meaning. And that clear, unequivocal language should have been the end of the inquiry. The inquiry should have ended not only because the provision's language is so exceptionally clear, but because, as ISP pointed out during the circuit court hearing in Mr. Burgess's case, that the way to get a copy of your application or denial letter is not by making a FOIA demand of ISP's FOIA officer, but to contact the Firearm Services Bureau directly. No one is trying to keep people's personal applications or denial letters a secret from them. But the Firearm Services Bureau needs to be able to verify that you are who you say you are before releasing copies of your confidential information.
Counsel, is your argument that with a FOIA request, someone does not have to provide that level of proof?
They do not, Your Honor. You don't have to prove that you are who you say you are. And when you make a FOIA request in Illinois, you don't even have to give your real name. And people have made FOIA requests using pseudonyms. But if the information is truly public, then it doesn't matter. Anybody's entitled to it. Any person who asks for it is entitled to it.
So providing the identifying information, proving you are who you say you are, really doesn't solve the question, right?
People can get, if people go to the Firearm Services Bureau and ask for their own copies of their own documents, they can get copies of their own documents. The conundrum is you don't want to release this information to just anybody. And when anybody can make a FOIA request, ISP has to satisfy itself that the person who's asking for it is the person to whom it belongs. I do not believe the permanent injunction could be read to say that somebody can't get a copy of their own documents from the Firearm Services Bureau. That was more addressing the fact that the Associated Press back in that day had made a request for the names and the expiration dates of people's FOID cards, and the public access counselor at that time looked at the law as it was, because that was before 7.5e, and determined that that information could be released.
The crux of your argument is that FOIA is the wrong vehicle for seeking this information, regardless of whether you're accompanying that request by identifying information, saying that you're truly who you say you are. under no circumstances is this information producible, for lack of a better word, under FOIA. Is that your argument?
According to 7.5B's plain terms, Your Honor. The headquarters in Springfield, take your driver's license. I think they even have a kiosk in the foyer.
So again, the argument is that FOIA is not the proper vehicle for people to get their own information for their FOID card revocation or suspension. You have to go through the Firearms Services Bureau and bring information so they can verify it's you. And you had the issue of previous precedents when it comes to the media's requests for this type of information years ago. If you recall that whole questionable series of stories when somebody from the Associated Press was trying to request this type of information. We'll hear from Thomas Magg. He's the attorney representing the plaintiffs in this case next. So stay tuned. It is here with Springfield's Morning News on WMAY. All right, let's get back into it. Attorney Thomas Magg in front of the Illinois Supreme Court arguing the intersection of FOID and FOIA.
All documents in the government's hands are presumed, strongly presumed, to be disclosable.
Counsel, what about the injunction that your opponent just raised? What do we do with the injunction? With respect to this particular request?
Every court that has considered it has found that the injunction is inapplicable, and I agree that it is inapplicable. And the reason that it is inapplicable is what was sought to be enjoined from disclosure is not a person's own records to themselves. What was sought to be enjoined was production of lists of FOID card holders to third parties, specifically newspapers, although it's not limited to newspapers based on the legislative history of 7.5b and what prompted the lawsuit, and the risk that this information would be published in a public forum. And there is nothing in the applicable injunction that even comes close to saying the state cannot produce records to the person that either created those records or which has already been sent to the plaintiff in this case. They simply lost their copy and they're seeking.
Can I ask another question? What is your response to the assertion that FOIA was the incorrect vehicle for seeking this information and that there was another appropriate vehicle that is in place for the parties to get this information without using FOIA?
It's obvious that counsel has never tried to get any documents out of the State Police Firearm Services Bureau. In some, they don't answer the telephone for hours at a time. They don't answer emails for days and or weeks at a time. I mean, I invite this court to go to their website and dial the telephone number and see how many hours it takes to get a person, if you even can.
Obviously, all of this is way beyond the record here.
That was what my next point was going to be. We're all talking about things that are outside the scope of the record, but if asked, I'm doing my best to answer the court's questions. And there's a line on there required by law that says, this is the reason that we are suspending, revoking, denying your FOID card. At the end of the day, that's what we're interested in. Sandra Hart, Kenneth Birch doesn't need to be told what their own name and address is. They do want to be told what the stated reason they're not being allowed to have a FOID card and thus exercise their Second Amendment rights is, so that they can determine whether or not they can challenge that or not. And if they choose to challenge it, there are two mutually inconsistent mechanisms to do so depending on the reason that's articulated by the state. One is through an administrative hearing, which is for certain categories of denials, revocations. The other is a circuit court action for other categories of denials, suspensions, revocations. And never the twain shall meet. You can't.
Specifically, the following shall be exempt from inspection and copying. Information. What is you saying that you are requesting that does not fall into the legislative plain language as to these documents cannot be discovered under FOIA?
All right. We're not looking for our own clients' names. We're not looking for our own clients' addresses, their FOID card number, their social security number. We're not looking for our own client's date of birth. We know all of that. What we're looking for is what the state did, what its articulated reason was, when you get right down to it, for denying, revoking, suspending our clients' FOID cards, so that we can determine whether or not it's factually accurate.
And why does that information that you're asking for not fall within this specific statute? That's that question we're asking over and again. Specifically, the legislature said these documents are not available for inspection and copying under FOIA. Explain to us how your request does not include any of those long list of documents.
One, as noted by the appellate court, in Section 7, it makes clear that private information, the person there's an exception for their own information. We're seeking our own information. Two, the information we're seeking is not about the person. It's why the state did what it did.
So again, the arguments the state has is FOIA is not the right vehicle. You need to go through the Firearm Services Bureau. MAG saying, has anybody here tried to go through the FSB because they don't answer phone calls or respond to emails for weeks at a time. So we'll see where this goes. The court has taken that case under advisement. Just absolutely fascinating.
From the Fly SPI studios, take the easy way out.